We are back on record for the conclusion of the review, permanency planning hearing, and request for termination of parental rights on this case. May I have the names of our participants, please?
Good morning, Your Honor, Nicole Underwood, lawyer, guardian ad litem for the minor child.
Ms. Saja Thomas, counsel for the department. Ms. De La Garza.
Brandy De La Garza, the foster care worker from Fostering Solutions.
Michael Brooks, I represent Harold Hollis, father of the child.
Harold Hollis. Michael McFarland, representing mother.
Eric Hollis.
Thank you.
Thank you. All right, Ms. Thomas, if you could, I think your microphone is a little quiet this morning. But other than that, what I have in my notes, ladies and gentlemen, is that we are at the point where I'm just looking for your closings, and then I would make my decision. Is there anything else that we need to address on the record before we head into that?
Not from my end, Your Honor.
That's also my understanding, Judge.
Okay. All right, Ms. Thomas, let's start with you. We're going to let Nicole Underwood, our guardian ad litem, go last so she can hear everything everybody has to say before I listen to her recommendations.
Thank you, Your Honor. Majority of my closing, I would rely on my petition that was filed in this matter in July, asking the court to terminate the parent's parental rights so the child can be freed for adoption. Majority of the petition relies on the fact that the parents have either not complied or engaged in their case service plan or have failed to benefit from it. And under MCL 712A point 19B3 CI, we do have two parents who have been respondents for 182 or more days since that initial case service plan was entered. And the conditions that led to adjudication, this court will recall, there were concerns about domestic violence in the home. At first, there were allegations of some severe physical domestic violence, and also about potential drug use, and then the living conditions for the child. And Your Honor, during this what we've not been able to really thoroughly develop as relates to the parents has been the substance abuse component. Ms. Hollis lately, or more recently in the last two review hearings, I believe, has finally admitted to that. And Mr. Hollis, despite having those 3 positive screens, continues to maintain he does not have a substance abuse problem. However, he did not provide any information or evidence to us, or even provide us the name of the medications that would provide a false positive for methamphetamines. During this case, we've also had numerous reports from therapists indicating that there is concern about the potential power and control dynamic within that relationship. And just a few days ago, we've heard from both parents that they do not believe that there are any issues in their relationship as relates to domestic violence, because verbal or oral arguments are not domestic violence, since it's not physical. And from the parents' perspective, their issues have never harmed their child. And I think that's the real crux of where we have to rely on the information we have from the service providers, the trauma assessment, the psychologicals, that there is a harm to this child, that this child has experienced a significant amount of instability and a hostile home environment when she was with the parents. The police had found her hiding in a ditch with Miss Hollis, and to say that she was not ever harmed is really concerning, that there's no awareness of how their behaviors, their words, and their actions towards one another and to others in front of the child can lead to emotional harm. As this court will recall, parenting time was suspended back in early January of this year, based on reports from Ms. Moore and from the agency that there were some inappropriate behaviors, not necessarily towards the child, but in front of the child towards other adults in the room. One of the things that stood out to me from this case that I recall was Mr. Hollis was upset about the clothing his daughter was wearing, referred to it, I think, as secondhand or trashy clothing in front of her. And while that might have been his opinion to say it in front of his child, I think that there's a lack of awareness of what that can do to a little one's psyche. Moreover, we've heard from Ms. Hollis numerous times now, or at least since our last review hearing, about her intentions to get inpatient treatment. And I want to say that she's probably in a contemplative state in her recovery, if she has maintained her sobriety the last few days. And we don't have any tests to prove that. We don't have a substance abuse assessment to kind of go through. There's been a real lack of acknowledgement of the issues at hand, Your Honor. As relates to the best interest, I think that this court has significant information within the court record to prove by a preponderance of the evidence that it is in this child's best interest for her parents' parental rights to be terminated. Although she is in a relative placement, and I know that this court must consider that, these parents have indicated on the record and by their conduct have indicated that they do not want to have a relationship with the relatives who are providing care for their daughter. And that has not availed them to alternative options for permanency, like a guardianship, or being able to be around her more during family functions, or those holidays that we sometimes will get when we have those family placements. So in this case, that does not weigh against termination. I would like to give credit to the parents for updating their home in order for it to become more prepared for the child to come home, Your Honor. But at this time, it's been a year and we still have limited acknowledgement and progress. And so I don't believe that at this time that their home environment would be appropriate for the child. The child is in a home that provides for her needs. She has developed strong emotional attachments to the caregivers and to the other relatives that are in that home and their extended relatives. And I believe that the parents' lack of compliance and benefit from their case service plan speaks volumes as to their parenting ability. And Your Honor, for those reasons, we are asking the court to grant the relief requested within the petition. Thank you.
Mr. McFarland, would you like to go next?
Sure. One thing I'd like to point out is the operative word of the attorney for the agency is that parents' actions can lead to emotional harm to the child, not that it did lead to emotional harm of the child. We've had no expert testimony during the trial that I recall that their actions, verbal actions, led to any emotional harm to the child. Their house is much better than it was, and the agency is in no position to
The stage is set as the judge and lawyers prepare to clash.
immediately return the child. I think this case is, we're taking an analogy, is like a big cruise ship. It's very hard to get turning. And once it's on course, it's very hard to veer off course. And I think these parents have made that turn straight. That mother has indeed acknowledged that she has a drug issue and she wishes to address that. That's a really big turnover. Of course, they've been denied parenting time for some time, but when they last met with the child, there still was a bond with the child. And there's been no testimony that there wouldn't yet be a bond with the child if they were to have parenting time, Your Honor. Couples argue. I don't know any couple that doesn't argue. Walking away, like this couple did during the last argument, seems to be a proven course that's taught many times, to walk away from arguments. Take a break. Appears to be what they did. The client did testify as to the best interest factors in this case. They do have some physical issues. I haven't heard really any type of accommodation for that. At this point, the question is there an expectation that in a reasonable amount of time, they can get their act together? And I think they're well along that path. Their income seems to be sufficient. They've made improvements on the house. Now, DHHS, per policy, they don't remove a child if parents are functional addicts, Your Honor. Mother seems to be functional. She seems to be, we haven't heard any stories of any reports of her being passed out, of her in a ditch as the initial allegations were on this case. We haven't heard any of these bizarre ideations or behaviors. We believe that their expectation can be met by the parents, my client, that they can achieve the goals of the case service plan. We're asking that the court not terminate the parental rights and restore parenting time so they can come to a closure on this case. Thank you, Your Honor.
Mr. Brooks?
The 1950s, there was an anthropologist considered to be the finest educator in the world at that time, named Margaret Mead. And she had studied many different cultures, found that when measured against what we would consider the norm, they deviated considerably from the norm. But she didn't consider those to be deviant behaviors because they were not presenting problems to the culture as a whole, their culture as a whole. Now, in our case, I will be the first to acknowledge, it's no secret, that Harold Hollis is frustrated by being in this situation and thinks that the taking of his child for the length of time he has is an injustice. Harold tends to express his frustration in a way that is not, how would I put it, socially acceptable in many ways. And he has unintentionally, I believe, communicated an attitude that he does not in actuality share. He has a stable relationship with his wife. They have a child, now a 3-year-old child together. I can tell you that the way I met Harold Hollis was he was operating a business of his own, and I hired him to do some work in my yard, which he did a fine job, and I paid him for it, no complaints. But if you were to ask him how he feels about me, or this court, or the DHS and its staff members, you would probably hear something that sounded to our ears offensive. And that can lead to a false impression. The fact is, he has not harmed his child. He has not harmed his wife. To my knowledge, he's never harmed anybody. But if you listen to him talk, you'd think he was a semi-controlled bear of a man. He's not. He's just a normal guy with a limited education and a limited vocabulary who uses the vocabulary he knows how to use in a way that's offensive. I've had many cases where the client really wasn't that bad, but they just weren't going to cooperate verbally and accept the authority of a court or the department. And I think verbally that's what you're getting from Harold, but I don't think he really is acting that way. And I would hope the court would take that into account when deciding whether or not he and his wife should have another chance to raise a child. Thank you.
Ms. Underwood?
Thank you, Your Honor. As I say in many of these hearings, termination trials are never easy, and it is my job to look out for what is in the best interest of each minor child that I represent. It's hard to watch parents who come back review after review and fail to really see or acknowledge any type of wrongdoing that has impacted their child, and acknowledge any reasoning as to why we're all involved to the point that we are. While I appreciate that the parties have done some work when it comes to parenting classes, the blatant disregard to acknowledge substance use on behalf of Harold continues to be a problem. He's attended a substance use evaluation and declined to indicate he had any substance problem, so there was nothing that could be done there. And Miss Hollis did the same thing. It took her a year to acknowledge that she had any substance use disorder or drug problem. And when she did in the June hearing, she said she would be going on Thursday to check herself into inpatient. And here we are, it's almost September, and she hasn't done anything to acknowledge that issue or to
The state comes out swinging with chilling details of neglect, from drugs to violence, even a child hiding in a ditch.
further it. I confirmed with CMH, there is not a 3-month wait list for substance use disorder inpatient treatment. It's at most a 2-week wait. So, I mean, realistically, Ms. Hollis could have been at the near end of her substance use disorder treatment and on her way to recovery. However, she's still sitting in the courtroom today and hasn't taken any steps in order to address that issue. It's interesting that Mr. McFarland said that the parties now know how to deal with conflict. They just walk away, yet he failed to mention the fact that his client locked Mr. Hollis out of the house, and then Mr. Hollis proceeded to break a window to get back in. There continues to be police involvement. There continues to be arguing and fighting. Again, the parties are downplaying it now, but the police reports in the initial petition indicate otherwise. The dysfunction in their relationship is far beyond just fighting. It's not functional or healthy or in the best interest of any child. Mr. Hollis's refusal to participate in any services, again, shows his stubbornness is winning out over taking the steps and putting in the work to get his daughter back. And that's unfortunate. But again, the department can only help provide services and give options and assist with those things. They can't make the parents do the work here. And I believe the department has gone above and beyond to try to assist with connecting the parties to these services in order to try to get their child back. And they have, again, Mr. Hollis has done very little. And Miss Hollis, again, has failed to treat her mental health and her substance use disorder. She's been hospitalized. Miss Hollis has been hospitalized for her mental health and even had some paranoia or some sort of hallucinations during her psych eval. So again, her mental health is still also untreated, or at the very most, only at the beginning, since she just started engaging in services again. Again, Your Honor, I never really like to recommend termination. However, in this case, the parents have done very little to benefit their daughter. And if she were to be returned to their care today, she'd be in the same situation that she was in a year ago. And that is truly not in the child's best interest. She is in a place now with relatives that care for her, that provide her with her needs, that provide her stability, consistency, and a healthy family environment. So again, it's unfortunate that we're here today, but again, I do think that it is in the child's best interest, based not only on the petition and the lack of services that the parties have engaged in, but also it's unfair to this child to continue waiting for permanency while her parents may or may not put in the work in order to better themselves for the benefit of their child. So I would ask that the court proceed with termination of parental rights today. Thank you.
Thank you. Well, the court finds all interested parties were given notice for purposes of today's review, permanency planning hearing, show cause hearing as it relates to both parents, as well as the request for the court to terminate parental rights of both parents. As it relates to the review, I do find reasonable efforts towards the goal of adoption at this point are being met. The secondary goal remained, or not necessarily the secondary, but the alternative goal remained reunification. And to her credit, Ms. De La Garza continued to try to keep track of the parents and to refer them to services and to monitor those services. And those details are outlined in the court report, as well as her testimony that was taken earlier on this review hearing. A couple of good examples are tracking Ms. Erica Hollis's attempts at rehabilitation around substance use and how that is playing out as it relates to her progress in that area. That's inextricably tied to the progress in the area of her mental health treatment. She's been in and out of several different services, and Ms. De La Garza continued to report on her efforts all the way up until this last hearing. She also continued to try to keep track of Mr. Hollis. Unfortunately, that included keeping track of the times that the police intervention was necessary at the home of the parents. But technically speaking, all of those things are considered reasonable efforts towards the alternative goal of reunification, which is tracking the client's progress on their case services plan around treatment for substances, mental health issues that were highlighted at the outset of the case and continue to be issues as we went through the reviews all the way up until this last hearing, regardless of the goal change at the hearing before this one. It also included tracking the progress on the Orchards Family Assistance Program. And of course, all the documents that were supplied in support of her report. Our guardian ad litem is also certainly in compliance with her obligations to the family, and I appreciate the advocacy of our attorneys this morning and in prior hearings. As it relates to the show cause for failure to follow the case services plan, that is inextricably tied to the court's findings as to whether or not there's been progress made on those case services plans. The burden as it relates to a show cause is obviously similar to a burden in a criminal case as it relates to the burden, since a show cause could potentially result in incarceration or some other fines and costs associated with contempt of court for failure to abide by the court's order. I do find that objectively speaking, and by their own admissions, Mr. Hollis is refusable to engage in case services around substance abuse, in counseling, and even communication with Ms. De La Garza, visitation are all irrefutable proofs that he is, and he's told us that he doesn't trust anybody and that he has frankly, no intention of engaging with the services that have been instituted for him. There was some limited testimony that he's engaged in counseling, but as I really looked at those proofs, I think I only saw like 2 visits in the last report period, and that's over the course of the entire case time frame. Ms. Erica Walker is not currently engaged in services. She indicated at the Orchards family, she indicated to Tyler Korwicki at the tail end of her Orchards Family Services planning that she wished to check herself into a rehabilitation program, and that was why they closed their case. And that's what's cited at the back of the closing report on that. She herself told us she was going to go to rehabilitation and try to get some treatment for substance abuse. She's admitted on record that she's using methamphetamines as recently as 5 days ago. So those are clear indications that she's disregarded her case services plan, and that would be considered contempt of court.
Parents' struggles unravel. Denial, hospital stays, no progress. The state pushes for termination, saying the risks remain.
As it relates to the consequences for a contempt of court, I'm simply going to note as part of today's findings and in support of my decision to terminate the rights of both of these parents, that is certainly a contributing factor to the court's decision in agreeing that there is clear and convincing evidence to terminate their parental rights. So I'll note that in the court order as it relates to the request for review of the show cause. As it relates to the termination of parental rights, the court is asked to look at that as a two-phase series of findings. The first is to determine whether there's clear and convincing evidence to support that the statutory grounds for termination of parental rights has been established. Second is to determine if it's in the child's best interest to terminate the parental rights by a preponderance of the evidence. The sections of the statute that are asked of the court to consider do include the provision that relates to failure to complete case services and whether or not there is a time frame, a reasonable time frame during which the parents could potentially comply with those services and benefit from those services. And that's found under MCL 712A.19B3CI. In this case, certainly the respondent mother and father were respondents in a proceeding brought under this chapter more than 182 days ago. Specifically, the disposition and initial case services plan adjudication was done by trial on 9/9/24, continued to the 13th, and then the initial disposition took place October 7th, 2024. So certainly more than 6 months or 182 days, and that was as early as both parents. At that time, a case services plan was entered that outlined the abuse, neglect, dynamics in the home, the domestic violence dynamics between the parents is articulated during the trial, found by the court during the trial. We had, of course, the psychiatric issues that mom was experiencing here, Ms. Walker. Finding her in the ditch, for example, officers, her admitting that she's hearing voices even during her psychological evaluation, and frankly, as recently as in the last report period to her counselor, one of the last times that she went to see her counselor. At that time, she was in and out of Mr. Hollis's home. They were not married. During the course of the period of time that the case has been open, they did get married. Mr. Hollis did not engage in case services in any real substantial way. Demonstrated some skills around interacting with his child during parenting time, during the trauma assessment, but he also demonstrated a really significant disconnect around understanding how his fight with Ms. Erica Hollis now, as well as his approach to parenting are detrimental to the child. So some examples of that are during the trauma assessment, the child demonstrated a fear of men. She had been, the family at the outset of the case was refusing to allow their daughter to be evaluated by early on, refusing to engage in some kind of Head Start programs or any kind of education or analysis of what her needs could be. She, at the time of removal, had significant physical limitations noted during the CTAC. Specifically, they were evaluated. She had some vision issues. She demonstrated food insecurity signs with shoveling food into her mouth, for example, hiding from people. She had some real indications that she had seen the domestic violence dynamics in the home and that had affected her. She had some delays that were being ignored. She was literally found the borderline risk in areas of cognitive functioning, receptive functioning, fine and gross motor skills. So the parents showed some skills in bonding with the child, especially the father more than the mother. The bonding assessment with the mother was a really a more disconnected bond there, even at the time of the CTAC, which was put into evidence, I should say, at the time frame for the initial disposition back October 7th, 2024. So it had been done before that. You know, mom had described the child as bad, as a bully, who would deliberately do things, bad things, and laugh about it. The child was not really very interactive with her during that assessment. She would command the child to do some things, but really wasn't able to play with her, had a lot of trouble keeping up with her due to her physical limitations. And the child really didn't demonstrate that she wanted to go to her mother. She went to another person who was present there during the evaluation for comfort. And really the child refused to engage with her mom on the activities that took place during that trauma assessment. Dad's involvement indicated that he had decent interactions with the child, but he talked with her about things that had nothing to do with things that she would particularly be interested in, repairing cars and some other items and issues, and really didn't engage in any parenting time to demonstrate that he understood how to take care of her or any regular caretaking skills for his child. At the time of the removal, Erica Hollis had taken the child, left the home. She was clearly in the middle of a psychotic episode. And Mr. Hollis had not even really reported that anything was going on. Wasn't reporting concerns about how that could affect his daughter. So I think in short, he'd like to hang out with her. And he certainly cares about his daughter, but as to understanding how his decisions to use substances and how to resolve conflict in the home were really affecting her. And his failure to understand or refusal to understand her basic needs and her developmental needs also significantly affected her. She has a litany of specialized services that she continues to engage in order to overcome some of those.
The judge lays out the evidence with precision and weight. Every failure stacked against the parents grows more clear.
Limitations as a result of the delay in attention on those areas. I want to talk for a moment about the psychological evaluation and Harold's interview with Renee Moore. Both parents have some physical limitations, which is really just a minor issue as it relates to their interactions with the child, with the exception that it does contribute to their inability to keep her safe. She's a toddler, she's moving quickly. During the investigation into the home, it's only been very recently that the child's home environment potentially with the Hollises would have been even remotely safe. For a long time, for several review periods, I was hearing about how the child's room was stripped down to a subfloor, that the house was under construction, that it was not livable for a child or safe for a child at that time. They did remedy that. And in the meantime, the child is working on her developmental delays in the areas of fine motor skills, cognition, language and communication, emotional regulation, and coping skills. Harold, during his interview with Renee Moore, denied any domestic violence issues or any other issues, despite evidence at the outset of the case that he did have a drunk driving. And then, of course, I had ordered substance abuse services and an analysis because of that indication. During the course of the case, he did take some drug tests that did show up positive. So there was clearly an indication of substance issues there that arguably, if he resolved those, could have helped him resolve some of the domestic violence dynamics in the home, helped him develop some conflict resolution skills that didn't involve things like breaking windows in order to get back in the house, which happened just recently, or some of the other litany of phone calls that were tracked and received by the court during the course of time, interactions with neighbors that resulted in police calls, his interactions with his wife that resulted in police calls. I mean, these are not, it's sure every couple fights, but not every couple has fights that regularly require police involvement and attention to make sure that nothing significant is happening or no one needs to be arrested. And those are dynamics that clearly affect a child's ability to work on their skills, and did affect her here. And we have documentation of that. So the claim that really there's no harm, no foul here because of the way the parents interact and their substance use and their failure to look at their psychological issues, that really fails when you look at the proof that the court received over the period of time that this child was in care. She's still in on many of those services to try to overcome the challenges that she faced while she was in the care of her parents. And she has made progress since then, which I will say has been great. So, Mr. Hollis has clearly not made progress in the areas that he needed to around substance use, dynamics in the home, psychological interventions to try to reduce or eliminate the conflict in the home that has affected the child. He has not made progress in the area of understanding developmental needs of a child or how to take care of those needs or how to support the special needs of his child moving forward. And it's been nearly a year. 6 months is the time frame that the court is asked to look at by statute. It's been more than 6 months. She's a very young child. She needs safety and stability. So I cannot find that there's any reasonable likelihood that the conditions created by Mr. Hollis will be rectified within a reasonable time considering the child's age. And under subsection J, which is the other section that the court's been asked to look at, that there is a very much a reasonable likelihood based on his continued demonstrated conduct and lack of capacity in parenting that this child would be harmed if returned to the home of Mr. Hollis. We went through a lot of the details on that during the last report period, and I've highlighted many of those. The record really speaks for itself. The arguments have been made also very well by Ms. Thomas and Ms. Underwood during different review hearings. And I think I've hit on a couple of the things that really demonstrate that as recently as June. The police involvement in June. It was noted at our last hearing that he remains verbally aggressive and combative towards service providers when he disagrees with them. The drug screens were positive for methamphetamine and amphetamine, despite denial of use of those substances. He denies, he says that he's always been prepared for visits, that when the child was in his home with Ms. Hollis, he remarked that their relationship was great when she was there as to his daughter. Which is really quite remarkable when you look at the petition for removal, which noted that Ms. Hollis was found in a ditch in a psychotic episode, and him not concerned about that piece at all. As it relates to the relative placement piece, I'll address that when we get back to the second aspect of the best interest factors findings. But he was very consistent during hearings, indicating that he's all dead to me. As to the relative placement, he was very angry and upset when the child was placed with relatives and blamed relatives as well as the department and the court for the removal. When he was asked why the child was removed, he said, quote, "Because my sister's an asshole, that's why," quote. He even became combative with his own attorney when going over the report. And I understand that this is a high stress situation, but these are just further demonstrations that the dynamics in the home that were identified at the outset of the case remain in full force and effect. Those dynamics very clearly affected this child, and she would be at significant risk of harm if returned to his care. As an extension of that, Ms. Hollis has decided that the best way forward for her is to marry Mr. Hollis during the court period of jurisdiction. So obviously that places, if her child were to be returned to her, that would place this child squarely in the home of Mr. Hollis, at risk of all of the indications that the courts just reviewed. Secondarily, she too has failed to benefit from services in any significant way during the period of time that the case has been open. There were some really serious, significant psychiatric issues happening for her. They continued over the period of time that the court's jurisdiction was open. She was hospitalized in December of 2024 for a potential suicide attempt. And this was one of, I think, 4 prior attempts, one of which was just a few months before that, as I recall, roughly. We, of course, had the continued domestic violence that was happening in the home, or the reports of domestic violence. We have police show up as recently as June 4th, 2025, wherein she was
Father faces harsh words, substance abuse, and police calls. The court highlights chaos at home and zero accountability.
recognized as having a mark on her face, but denied that anything got more than physical or more than verbal, and didn't seem to have an issue or to think that it was an issue at all, that the verbal argument escalated to the point that she did sustain an injury, whether that was directly from Mr. Hollis or from the breaking window glass. Her remarks on her progress indicated that she is calmer now, which is great. She, for example, is not living in a car. She's not running away every 5 minutes or attacking Harold, which were all remarkable to the court. And also really are admissions of the kind of things that were clearly happening at some point in the past, which just goes to show that the dynamics in the home were not okay at the time that the child was removed, and that they were deviations from the norm to the extent that they were causing harm to the child. Let's see. She had not engaged in inpatient treatment, as Ms. Underwood noted. She had not engaged in outpatient treatment for AA or NA. She remarked when she was asked about the removal that, quote, "We didn't hurt her. She was going to her doctor's appointments. We were doing what we were supposed to do." Some of her other remarks included, "We didn't do anything wrong. Okay, I have a substance problem, but I can fix it." So these are, again, remarks that indicate that there's a real disconnect here in understanding how the dynamics in the home were directly affecting the child, how her failure to take care of her mental health were and the outgrowth of that, whether that's attacking Harold, hearing things that weren't there, or failing to notice when her daughter needed services, or taking her to those services. All of those things were affecting her child very significantly. And as recently as in the last couple of weeks, she still does not understand that that's affecting the child. The court finds certainly that that is a serious indication that there is no reasonable period of time, considering this child's age, that the conditions that led to the adjudication would be remedied. I also find that not only because of her continued residence with Mr. Hollis, but because of her own lack of progress, her continued intermittent at best treatment for her psychiatric issues. For example, she's discontinued from several different service providers. She's in and out of psychiatric care and counseling. We had the remark from Orchard Family Services that those services were terminated because she was going to go for inpatient services around her addiction, which really is significant backsliding and discovery of how significant that identified issue really is and getting in the way potentially, or it was just another excuse because she really didn't think that there was anything wrong and didn't really think she needed to engage in learning about how to better parent a child. So for whatever those reasons are, she continues to have all of those struggles complicated by her use of methamphetamines. It's in significant disconnect in understanding her child's significant needs, or the gaps that were in place that led to those significant needs. So I do find there is clear and convincing evidence also to terminate her parental rights under C, I, and J. There's no question there will be a significant risk of harm if that child was returned to the care of her mother today. As I look at the best interest factors, one of the first things that we address is the child-parent bond, which I have spoken to. Again, I think that there's affection there. Harold Hollis's interactions with his daughter, to a limited extent, do demonstrate that affectionate bond. There was really no, frankly, to put it colloquially, there's really not a lot of love lost between Ms. Erica and her daughter, as was noted during the CTAC evaluation. She's pretty disconnected, which is very consistent, I think, with what's been noted on her psychiatric issues, where she's really just not there sometimes. And I'm sure that her daughter was very aware of that and was aware that trying to rely on her mom, who maybe wasn't even seeing or hearing things that were there, was not the best idea, and certainly undermined the parent-child bond in those circumstances. But the bond associated with the father and the child also was marked by, obviously, the dynamics of domestic violence in the home, which was demonstrated by her fear of men, and the insecurity around food and hiding from people do indicate that, and I would say, and Mr. Hollis being essentially the sole provider for Ms. Hollis as well as this child during that period of time, can only be characterized as part of his parent-child bond with his daughter. So yes, there's a bond there that has some highlights, but for the most part, it's characterized by a lot of very dangerous things that significantly limited her development and caused her a lot of challenges that she continues to try to overcome. She's a very young child. She has a significant need for stability and permanency, especially given her continued struggles in those cognitive delay areas. Now they're looking at whether or not she needs to be provided with asthma support. She's going in for that evaluation soon. She's still doing speech therapy as she heads into preschool and already has an IEP for those things. She's been working on overcoming some of those developmental delays over the course of several different review hearings. We've heard about her progress in the home where she is now, which is a stable, safe, relative environment. Both of the parents failed to take advantage of the relative placement in some of the traditional ways. They both felt that the relatives were part of the problem since they took in their daughter, since the relatives took in their daughter and really cut themselves off completely from any kind of interaction with the relatives. So they weren't able to enjoy some of those potentially extra contacts, like during family events or holidays or phone calls. So despite the relative placement, I do find that it's in the best interest of this child to terminate the parental rights of both parents. We had, of course, that supported by our LGAL and the caseworker. The child is too young to express a preference. There is a high likelihood of her being adopted into the home where she is now. She is bonded with that household, which has provided her the safe and stable environment that she needs moving forward, the medical care and development care to provide for her developmental needs. So there's a lot of reasons that Melanie has done, or the child, I should say, has done as well as she has. And those are attributed, unfortunately, not to the parents, but rather to the department's decision to ask the court to remove the child and to require attention to this child for the challenges that she had and needed to overcome as a result of her exposure to her parents in her home. So we will enter an order terminating the parental rights of Harold and Erica Hollis. There will be no further efforts towards reunification or to prevent removal. The child will be directed to at the adoption completely from this point forward, and we'll monitor the department's efforts on that as we move forward, and I'll issue orders to that effect. Both parents have the right to appeal. The orders will be provided to them if they choose to exercise that, including an attorney if they can't afford one on their own. I'll go ahead and set a review hearing after we're off the air, as from this point forward, essentially, we're going to be operating under the adoption code, which is confidential. Unless there's any questions, that's all for today.
The hammer falls, parental rights terminated, adoption ahead. Justice is served as the court protects the child's future.